The Labor Code of the Philippines, Title 2, Wages, Chapter 1, Preliminary Matters, Article 97, Definition of Terms. Person means an individual, partnership, association, corporation, business trust, legal representative, or any organized group of persons. Employer includes any person acting directly or indirectly in the interest of an employer in relation to an employee and shall include the government and its all branches, subdivisions, and, and instrumentalities, all government-owned or controlled corporations and institutions, as well as non-profit private institution or organization. C. Employee includes any individual employed by an employer. Wage paid to any employee shall mean the remuneration or earnings, however designated, capable of being expressed in terms of money, whether fixed or ascertained on a time, task, piece, or commission basis, or other method of calculating the same, which is payable by an employer to an employee under a written or unwritten contract of employment for work done or to be done or for services rendered or to be rendered that includes the fair and reasonable in the fair and reasonable value as determined by the Secretary of Labor and Employment of board, lodging, or other facilities customarily furnished by the employer to the employee. Fair and reasonable value shall not include any profit to the employer or to any affiliated with the employer. This Article 98, Application of Title. This title shall not apply to farm tenancy or leasehold, domestic service, and persons working in their respective homes in needlework or in any cottage industry duly registered in accordance with law. Chapter 2, Minimum Wages Rates. Article 99, Regional Minimum Wage. The minimum wage rates for agricultural and non-agricultural employees and workers in each and every region of the country shall be those prescribed by the regional tripartite wages and productivity boards. Article 100, Prohibition against elimination or diminution of benefits. Nothing in this book shall be construed to eliminate or in any way diminish supplements or other employees' benefit being enjoyed at the time of promulgation of this code. Article 101. Payment by results. A. The Secretary of Labor and Employment shall regulate the payment of wages by results, including pacquiao, piecework, and other non-time work in order to ensure the payment of fair and reasonable wage rates, preferably through time and motion studies and in consultation with representatives of workers and employers' organizations. Payment of wages. 102. Article 102, Form of Payments. No employer shall pay the wages of an employee by means of promissory note, vouchers, coupons, tokens, tickets, cheats, or any object other than the legal tender, even when expressly requested by the employee. Payment of wages by check or money order shall be allowed when such manner of payment is customary on the date of effectivity of this code, or is necessary because of special circumstances as specified in appropriate regulations to be issued by the Secretary of Labor and Employment, or as stipulated in a collective bargaining agreement. Article 103, Payment, Time of Payment. Wages shall be paid at least once every 2 weeks, or twice a month at interval not exceeding 16 days. If on account if on account of force majeure or circumstances beyond the employer's control, payment of wages on or within the time herein provided cannot be made. The employer shall pay the wages immediately after such force majeure or circumstances have ceased. No employer shall make payment with less frequency than once a month. The payment of wages of employees engaged to perform a task which cannot be which cannot be completed in 2 weeks shall be subject to the following conditions. In the absence of a collective bargaining agreement or arbitration award. 1. That payments are made at intervals not exceeding 16 days in proportion to the amount of work completed. And 2. That final settlement is made upon completion of the work. Article 106, Contractor or Subcontractor. Whenever an employer enters into a contract with another person for the performance of the former's work, the employees of the contractor and of the latter's subcontractor, if any, shall be paid in accordance with the provisions of this code. In the event that the contractor or subcontractor fails to pay the wages of his employees in accordance with this code, the employer shall be jointly and severally liable with his contractor or subcontractor to such employees to the extent of the work performed under the contract. In the same manner, the extent that he is liable to employees directly employed by him. The Secretary of Labor and Employment may, by appropriate regulations, restrict or prohibit the contracting out of labor to protect the rights of the workers established under this code. In so prohibiting or restricting, he may make appropriate distinction between labor-only contracting and job contracting, as well as differentiations within these types of contracting, and determine who among the parties involved shall be considered the employer for purposes of this code, to prevent any violation or circumvention of any provision of this code. There is labor-only contracting, where the person supplying workers to an employer does not have substantial capital or investment in the form of tools, equipment, machineries, work premises, among others, or the work recruited and placed by such person are performing activities which are directly related to the principal business of such employer. In such cases, the person or intermediary shall be considered merely as an agent of the employer, who shall be responsible to the workers in the same manner and the an extent as if the latter were directly employed by him. Article 107. Indirect Employer. The provisions of the immediate preceding article shall likewise apply to any person, partnership, association, or corporation which, not being an employer, contracts with an independent contractor for the performance of any work, task, job, or project. Article 108. Posting of bond. An employer or indirect employer may require the contractor or subcontractor to furnish a bond equal to the cost of labor under contract, on condition that the bond will answer for the wages due to the employees, should the contractor or subcontractor, as the case may be, fail to pay the same. Article 109. Solidary liability. The provisions of the existing laws to the contrary notwithstanding, every employer or indirect employer shall be held responsible with his contractor or subcontractor for any violations of any provision of this code. For purposes of determining the extent of their civil liability under this chapter, they shall be considered as direct employers. Article 110. Worker preference in case of bankruptcy. In the event of bankruptcy or liquidation of an employer's business, his workers shall enjoy first preference as regards their wages and other monetary claims. Any provisions of law to the contrary notwithstanding. Any such unpaid wages or monetary claims shall be paid in full before the claims of the government and other creditors may be paid. Article 111. Attorney's fees. A. In cases of unlawful withholding of wages, the culpable party may be assessed attorney's fees equivalent to the 10% of the amount of wages recovered. B. It shall be unlawful for any person to demand or accept in any judicial or administrative proceedings for the recovery of wages, attorney's fees, which exceed 10% of the amount of wages recovered. Chapter 4. Prohibitions regarding wages. Non-interference in disposal of wages. No employer shall limit or otherwise interfere with the freedom of the employee to dispose of his wages. He shall not in any manner force, compel, or oblige his employees to purchase merchandise, commodities, or other property from any other person, or otherwise make use of any store or services of such employer or any other employee. Article 113. Wage deduction. No employer in his own behalf or in behalf of any person shall make any deduction from the wages of his employees except A. In cases where the worker is insured with his consent by the employer and the deduction is to recompense the employer for the amount paid by him as premium on the insurance. B. For union dues, in cases where the right of the worker or his union to check off has been recognized by the employer or authorized in writing by the individual worker concerned. And C. In cases where the employer is authorized by law or regulations issued by the Secretary of Labor and Employment. Article 114. Deposits for loss or damage. No employer shall require his worker to make deposits from which deductions shall be made for the reimbursement of loss or damage to tools, materials or equivalent supplied by the employer, except when the employer is engaged in such trades, occupations, or business where the practice of making deductions and requiring deposits is a recognized one, or unnecessary or desirable as determined by the Secretary of Labor and Employment in appropriate rules and regulations. Article 115. Limitations. No deductions from the deposits of an employee for the actual amount of the loss or damage shall be made unless the employee has been heard thereon and his responsibility has been clearly shown. Article 117. Deduction to ensure employment. It shall be unlawful to make any deduction from the wages of any employee for the benefit of the employer or his representative or intermediary as consideration of a promise of employment or retention in employment. Article 118. Retaliatory measures. It shall be unlawful for an employer to refuse to pay or reduce the wages and benefits, discharge, or in any manner discriminate against any employee who has filed any complaint or instituted any proceeding under this title or has testified or is about to testify in such proceedings. Article 119. False reporting. It shall be unlawful for any person to make any statement, report, or record filed or kept pursuant to the provisions of this code, knowing such statement, report, or record to be false in any material respect. Chapter 5, Wages, Wage Studies, Wage Agreement, and Wage Determination. Article 120, Creation of National Wages and Productivity Commission. There is hereby created a National Wages or and Productivity Commission, herein after referred to as the Commission, which shall be attached to the Department of Labor and Employment for policy and program coordination. Article 21. Powers and functions of the Commission. The Commission shall have the following powers and functions. A. To act as the national consultative and advisory body to the President of the Philippines and Congress on matters relating to wages, incomes, and productivity. B. To formulate policies and guidelines on wages, income, and productivity improvement at the enterprise, industry, and national levels. C. To prescribe rules and guidelines for the determination of appropriate minimum wage and productivity measures at the regional, provincial, or industry level. D. To review regional wage levels set by the regional tripartite wages and productivity boards to determine if these are in accordance with prescribed guidelines and national development plans. C. To undertake studies, researches, and surveys necessary for the attainment of its functions and objectives, and to collect and compile data and periodically disseminate information on wages and productivity and other related information, including but not limited to employment, cost of living, labor costs, investments, and returns. F. To review plans and programs of the regional tripartite wages and productivity boards to determine whether these are consistent with national development plans. G. To exercise technical and administrative supervision over the regional tripartite wages and productivity boards. H. To call from time to time the National Tripartite Conference of Representatives of Government, Workers, and Employers for the consideration of measures to promote wage, res- wage rationalization and productivity, and I. To exercise such powers and functions as may be necessary to implement this act. Okay. Article 122, Creation of Regional Tripartite Wages and Productivity. The regional boards shall have the following there is a hereby created regional tripartite wages and productivity boards, herein after referred to as the regional boards, in all regions, including autonomous regions, as may be established by law. The Commission shall determine the offices, headquarters of the respective regional boards. The regional boards shall have the following powers and functions in their respective territorial jurisdiction. A. To develop plans, programs, and projects relative to wages, income, and productivity improvement for their respective regions. B. To determine and fix minimum wage rates applicable to their regions, provinces, or industries therein, and to issue the corresponding wage orders subject to guidelines issued by the Commission. C. To undertake studies, researches, and surveys necessary to the attainment of their functions, objectives, and programs, and to collect and compile data on wages, income, productivity, and other related information and periodically disseminate the same. D. To coordinate with other regional boards as may be necessary to attain the policy and intention of this code. And E. To receive, process, and act on applications for exemption from prescribed wages rates as may be provided by law or any wage order. And F. To exercise such other powers and functions as may be necessary to carry out their mandate under this code. Article 123, Wage Order. Whenever conditions in the region so warrant, the regional board shall investigate and study all pertinent facts, and based on standard and criteria herein prescribed, shall proceed to determine whether a wage order should be issued. Any such wage order shall take effect after 15 days from its complete publication in at least one newspaper of general circulation in the region. In the performance of its wage wage determining functions of the regional board shall conduct public hearings, consultations, giving notices to employees and employers, groups, provincial, city, and municipal officials and other interested parties. Any party aggrieved by the wage order issued by the regional board may appeal such order to the commission within 10 calendar days from the publication of such order. It shall be mandatory for the Commission to decide such appeal within 60 calendar days from the filing thereof. The filing of the appeal does not stay the order unless the person appealing such order shall file with the Commission an undertaking with a surety or sureties satisfactory to the Commission for the payment to the employees affected by the order of the corresponding increase in the event such order is affirmed. Were the applications of any prescribed wage increase by virtue of a law or wage order issued by any regional board results in distortions of the wage structure within an establishment, the employer and the union shall negotiate to correct the distortions. Any dispute arising from wage distortions shall be resolved through the grievance procedure under their collective bargaining agreement, and if it remains unresolved, through voluntary arbitration. Unless otherwise agreed by the parties in writing, such dispute shall be decided by the voluntary arbitrators within 10 calendar days from the time said dispute was referred to voluntary arbitration. In cases where there are no collective agreements or recognized labor unions, the employers and workers shall endeavor to correct such distortions. Any dispute arising therefrom shall be settled through the National Conciliation and Mediation Board, and if it remains resolved after 10 calendar days of conciliation, shall be referred to the appropriate branch of the National Labor Relations Commission or NLRC. It shall be mandatory for the NLRC to conduct continuous hearings and decide the dispute within 20 calendar days from the time said dispute is submitted for compulsory arbitration. Dependency of a dispute arising from a wage distortion shall not in any way delay the applicability of any increase in prescribed wage rates pursuant to the provisions of law and wage order. As used herein, a wage distortion shall mean a situation where an increase in prescribed wage rates result in the elimination of severe contraction of intentional quantitative differences in wages or salary rates between and among employee groups in an establishment as to effectively obliterate the distinction embodied in such wages structure based on skills, length of service, or other logical basis of differentiation. All work all workers paid by result, including those who are paid on piecework, takay, pakyaw, or task basis, shall receive not less than the prescribed wage rates per 8 hours of work a day or a proportion thereof for working less than 8 hours.